So I'm going to introduce the panel. I have probably the easiest panel to prepare for. I just let these guys go at it. I asked Mark this year that I not be the guy fighting with the plaintiffs alone. So let me introduce the guy who will fight with the plaintiffs. His name is I'm going to get this phonetically right, Jim. Jim Gizchek. And Jim's to the right of Brad Gall there. Speaking of Brad Gall, I think most people in the room know who Brad Gall is. He's one of the original cyber guys, wrote one of the first policies in the 90s. So not to say you're old or anything, Brad, but you weren't gray then. So that's Brad Gall, also to my right. Now, on bracketing the good guys are the bad guys. So immediately to my right is Chandler Givens. He's a bad guy, and he's going to argue with us and argue with everybody else. And he's going to really give you a sense of what the plaintiffs' firms are looking at and why they're looking at them and why they just won't go away. So, and to his right is, all the way to the right is Tim Blood. And I didn't have to go phonetically on that one. That was actually pretty easy. Tim flew in on his private jet from San Diego because he's a rich plaintiffs guy who sues all of your clients. So he won't actually admit to the jet thing, but I actually saw a picture of it, so you can challenge it later, but it's true. So one of the things we're seeing in this space is, everybody thinks, or at least they used to think, they understand what PII really is, right? It's defined in statutes, except it's not, and it's badly defined, and the statutes are changing, and the common law changes the statutes, and everything is a mix. So it's not quite as simple as one might think. Let's just be real basic on this one. And this is for the plaintiffs' guys. So my client loses a whole bunch of names and a whole bunch of passwords. I don't believe that's statutory trigger anywhere that I'm aware of. Do you care about that case?
Absolutely. It's on.
It's not yet. There you go.
That's on. Here we go.
That is still a very good case, even if it doesn't violate any regulation. Why? Because usernames and passwords in the hands of a true bad guy can be used even if somebody closes the account that the information was stolen from. Why? Because as we all know, we're all human beings, we tend to use the same or very similar usernames and passwords across all platforms for all different purposes. So if somebody, hacks into a Netflix account, gets usernames and passwords, then that hacker can go over to the Bank of America account and use the same and run the same usernames and passwords and then tap into somebody's bank account. And so those usernames and passwords have an incredible amount of value to them in the wrong hands, and that gives rise to liability.
So what are the litigation trends you're seeing, guys, and how are you taking advantage of them? And this is to you guys. And the way I'd like to run this is I'm not going to direct this to any one person, but the plaintiffs guys are going to jump in first generally, and then I want the other two guys weighing in after if possible.
So I'll add to what Tim said here. With respect to the username and passwords, the types of trends that we're seeing is that even when you're having this type of information stolen, it's a little bit less sexy than, say, if credit cards are being stolen. But if you are paying for a service, no matter what the service is it online or if it's offline, if a company is representing to you that they're going to take certain steps to protect that information, the standard languages, industry standard protocols, or commercially reasonable methods to protect the information, well, then that triggers a duty for them to do that. And so an argument can be this, that the amount of money that you're paying for that service, say it's $10 a month, what you can do is you can have a damages expert come in down the line of litigation and say, well, $2 of those dollars should have been expended towards reasonable security and privacy protocols per your representations to the consumer. So it becomes easy from a class action standpoint to say, look, what you have to do is give everyone back that $2. And so in the aggregate, that could be $2 per month for the past 2 years. For 3 million people, it adds up very quickly.
And our goal as obviously breach coach and defense counsel is we want to avoid even getting to that stage. We want to make sure that our clients are paying attention and not firing off notice letters that they've drafted on their own, which inevitably come back to bite them. But we want to make sure it's handled appropriately so we can hopefully avoid having to talk to the two guys on either end of me so that the client doesn't have to worry about a class action.
So 4 or 5 years ago, we would put this slide up occasionally, defense is eroding. It would have like one case on it. We were trying to make the argument that things are bad and getting worse, but now that slide would be 5 slides long. So what cases have you seen in terms of actual case law? We won't go too heavy in the case law, but what have you guys seen that makes it a little more easy for you and a little riskier for everybody else in the room?
Speaking sort of broadly, I think these cases, normally with a new area for plaintiffs' lawyers, typically what happens is the plaintiffs' lawyers get out in front, They have some early success, and then the defense bar ends up catching up and becomes more sophisticated in their defenses.
Don't give him too much credit, Tim.
And then the plaintiffs try to catch up, and then it goes back and forth, back and forth. It's kind of happened in the opposite way here. Plaintiffs' lawyers started filing these cases and really did not have much success at all. But these things are changing. I think they're changing for a couple of different reasons. One, the plaintiffs' lawyers are just getting smarter and thinking through their cases more and not sort of stepping in the traps they started stepping in
That's
originally.
questionable. Go ahead.
Right. And then two, I think another thing that happens a lot is judges are becoming more educated. So like usernames and passwords. Most judges that you go to are going to say, because they don't understand this area, they don't understand technology. Lots of times they're older, so they're not as tech savvy as younger people tend to be. And so judges didn't appreciate these kinds of cases. Gee, somebody got hacked. They're really the victim, that poor company, and now these class action lawyers are coming in and going after that victim. Gee, that's just not fair. But judges are starting to figure out that there really are, that the defendant really perhaps was negligent, and there are consequences to that information being taken and being out in the public. And so they're starting to understand these cases, and the plaintiff's bar, I think, is getting a lot better at educating judges about it. That, and you just see a whole lot more, the public is much more aware of it. Politicians are much more aware of it. You see much more legislation being passed or in the works of being passed because people are starting to appreciate the fact that this is a really serious matter when people's private information gets stolen.
And from our standpoint, as you look at the cases that have come out in the last 3 years, they are so fact-specific because, as you mentioned, if the company was negligent or if there was an intentional hacking by someone versus the lost laptop, all of those facts are very critical on how the court's going to rule on some very important issues, including standing issues, which up to this point, the defense bar has been able to get most of its clients out of these class actions very quickly, very early on, with very little spend, even though when I say very little, it's still not insignificant to get to that point. But those facts are just critical in each one of those cases.
Yeah, I think it's very important that you're able to draw a distinction around the two larger classes of breaches and privacy violations. The first is a fortuitous data loss, like a TJX or a Hannaford or a lost laptop case, where or a hacker, where a company is victimized by poor practices or by an individual breaking into a network. The second, and I feel it could be a little bit more egregious, is the bucket where a company is violating its own privacy policy, or a company's business practices are fundamentally objectionable in the minds of many. And there's one recent case involving a company called ComScore, which is really a data aggregator. And you go to the Drudge Report and you see the little banner on the side, 9 tips to destroy belly fat or whatever. You click on it to get the 9 tips, and surreptitiously, ComScore or another one of these companies' software gets downloaded onto your system. It's a persistent zombie-type cookie. It collects every bit of information you type. It logs your keys. It collects your credit card numbers, your passwords, and allows the company in the background to really create a very, very detailed profile of you based upon your input and your web searches and every detail around you. So in those cases where the business practice becomes the privacy violation, I think it's much easier for the plaintiffs' guys to go after it and really point to harm done.
Well, that's our case, so I can't speak too much about it. But I will say that case, just like the example I gave earlier, a lot of it's going to come down to what the company said they would do with their information, the consumer's information, and what they're actually doing with it. So the point being, I guess, the takeaway is whatever you're representing to the consumer, make sure that you have something to back that up in terms of the steps that you're taking to secure or protect consumer data.
Yeah. I think it's also with the hacker cases. So somebody had, a company keeps the data. Presumably they collected it appropriately, but they keep the data and then the data gets hacked. There's really two parts to those cases. The first part is, did the company take reasonable steps in protecting the data to begin with? And most of the time, the answer, or often the answer is no. But the second piece to those cases that you often see as sort of secondary allegations in these cases that make them a little sexier is, what steps did the company take after the hacking occurred? It's one thing to have your information hacked. I'm the victim, I'm the victim, I'm the victim. But then the next question is, what did the company do in response? And there's nothing better from the plaintiff's perspective than when let's say there's, they have customers all over the place. Some states require disclosure of a hacking, other states don't. The company goes and they send out the letter only to those customers that reside in the states that require notice letters. And then the letter is like, we're required by regulation to notify you of this minor little event that didn't really matter to anybody, and who cares, ho-hum, sorry to waste your time with this little letter, don't even bother reading any further. Those are fabulous letters. That is the worst way for a company to deal with it, because they're downplaying the real risk. And it provides the plaintiff's bar with an opportunity to come in and say, look, it becomes a cover-up case. They're not a victim. First of all, they allowed it to happen to begin with, and then when it happened, they covered it up. That's outrageous, and then it also provides a much more convincing argument for plaintiffs to obtain injunctive relief that says, okay, now, Judge, I think you ought to order the company to send out new letters that says, look, this is really bad what we allowed happen, and here are all the many, many steps that you need to do to protect yourself. So get busy changing your passwords and changing your account information across the board, and you're going to have to start monitoring all your information, because you never know when you're going to get hit with identity theft. And identity theft, that's one of those things where you don't have to worry about being on one of the coasts where all the liberals are. Identity theft is one of those things that scares the hell out of red state people as well. Those are the things that, my parents, they shred everything, right? I mean, people are really concerned about identity theft. It's right up there with personal security. So it ends up being something that is appealing to a lot of people, that a lot of people care about once they start learning about the consequences of a data theft.
And again, from our perspective as a breach coach, and for many of you in this room, you deal with this every day as well. The clients have an issue, they call, we think we might have a problem. Great, let's sit, let's talk about the letter. We think you should send it to everybody, and what's the initial pushback? Do we have to do it? Is it required? Well, if it's not required in all of those states, let's not do it, because we don't want to have to send this to more people than is required by law. Whether it's they don't want to spend the money, the time, the publicity, they don't want to do it. They don't want to listen. And of course what happens is, as our brother counsel here elaborates on, all they're doing is they're setting themselves up with some great facts for the plaintiff's bar when the class action gets filed. Right. But unfortunately, it's very difficult to pound that into the heads of our clients, to have them listen to us and do it correctly on the front end.
Now, I don't want to give away any secrets, but what he just said is absolutely true, because if there's a hard-fought litigation and eventually there's a mediation or something, we're sitting across the table from the other side, and the best opportunity I have is when they fail to listen to their lawyers up front on how to deal with it, and I get to lean across the table and say, you have a problem here, but I'm here to help you solve it. And then that's how you get a good settlement. And it just, the other side they want to just climb across the table and rip my head off, but that is really the position they end up finding themselves in crafting a settlement that is going to get them out of the problem that often they got themselves into.
But a lot of this is very consistent with the claims session earlier today. And it really speaks to the importance of having a team in your, as an insured, having a team in your corner that's able to come in and respond with a sophisticated, legal defense, as well as have the right PR folks, the right messaging folks, the right folks manning the phones at the call centers. Companies can diffuse the anger and the problems associated with a breach very easily if they've got a good team in their corner.
So I have two questions we must get to. I told you this would be easy for me. These guys are just going to keep talking. Here's the real question, the one of two for me. One is, how do you guys decide who you're suing and why. Is it just a numbers game? Is it a reputation thing? What is it?
It's usually not a reputation thing. I mean, from my perspective, I don't. If there's a company that is particularly sensitive to the reputation of having information leaked out, I mean, that's a plus, but that doesn't, in and of itself, make a good case. I want to look at what happened if it's a hacking case. What happened? What did the company do to or not do to prevent the hacking? And then, absolutely, what was the company's response? And if the best cases, and frankly, a lot of times both pieces are there. The company wasn't protecting. The company was very good at protecting its own proprietary information, but not so good at protecting its customers' information that it collected for its own commercial purposes. Judges like to hear that. And then what was the response of the company once they got caught? And those are the two pieces of it. And every fact pattern is different, but those two, if you have elements of those two pieces there, it's going to be a good case. And then as far as size goes, not every case has to be the giant, Sony 72 million people worldwide kind of case. It can be a much smaller data breach depending on the type of data that was stolen. But even with the type of data that's stolen, like I said, usernames and passwords, most of the time the data that gets stolen is of significant value. I mean, somebody can steal that data and then marry it up with other data that's otherwise available in the marketplace.
Cameron?
Yeah, I mean, very pragmatically, I'm not going to lie. We look at the number of consumers affected by a breach. We look at things like, one of the problems is being a plaintiff's attorney in this realm is that we have to wait a lot of times until an audit is finished to figure out what steps a company had taken to protect consumer data. So in many respects, we have to wait at least some amount of time to make sure that this wasn't some ultra-sophisticated hack where a company really wasn't at fault and they just had these guys or gals who were just really, really good at what they were doing and are able to break in. So we'll look at the steps that they had taken to protect consumer data, what they had said they were going to do. We'll look at the size of the breach. And, you have to look at the economics of it. We will look to see if it's a large company and it's a viable company, because if it's a company that's going to go bankrupt, if they have to defend a lawsuit for 2 months, then it might not be worth pursuing that.
So size matters in this case.
Yes.
Somebody had to say it.
Well, John, just one comment from our side. One of the things that we're seeing is, set aside the obviously the size matters comment for the guys on either side of me. What we're seeing, though, is a lot of smaller class actions that are flying under the radar. And this is an issue that, quite frankly, everybody in this room should be taking note of, because you get to read about the big cases, the Sonys, the TJXs, Hannaford. That's great. That's probably less than 1% of what we're talking about. But when you get into the 10,000, the 5,000, the 500 plaintiff case, it may not sound great because size may not fit your sizing requirements, but 500-person class action can get very expensive if you don't get out of it right away. And we're starting to see more and more of those cases crop up across the country, and they're not ending up oftentimes in federal court. They're ending up in state courts. We just had one in Wayne County, Michigan, in the heart of Detroit, and as you may venture a guess, the judges that we were dealing with were not as sophisticated, in part because they don't have the resources that the federal courts have, and we happen to be stuck there. And the rulings that you're going to get and the assumptions that they're going to make are much different than what you read about in the published opinions. And you need to be aware of that, because that seems to be, from our perspective, a very growing trend.
That's right. And it's also a delicate balance with your client when you're telling them you want to bump it to federal court and you have to allege it's over a certain amount of dollars. And they're looking at you like, why would you possibly say that in a pleading? So that gets tricky, too. And those state actions are out there. So the real question I want to ask is, and I asked this to you before so you know it's coming, is if you lose these cases, I mean, we win, you lose. That's the way this works so far. We win expensively, meaning it's getting harder to win, but we're still winning. We're still getting them knocked out. Why are you guys doing this? How do you make money? How do you stay motivated if the defense keeps winning these cases?
These are, it's either facts or law, and that drives any plaintiff's lawyer's decision to file a case. And with a lot of plaintiff's lawyers, it's the facts that drive the decision of whether or not to file. the facts in these cases tend to be very, very compelling, both to the plaintiff's lawyer who looks at it, and I think societally, they're very compelling. And you can look at the evidence that's out there. I'm from California. The Attorney General, Kamala Harris, is a Democrat, and her office has started a major enforcement initiative to crack down on privacy violations and hacking notification, things like that. So the question is why? And the easy answer is, oh, California, oh, a Democrat, please, come on, don't waste my time. Of course they're going to go after this stuff. It's frivolous, Democratic, plaintiff's lawyer, blah, blah, blah.
It's true.
Except, when you look at where Kamala Harris comes from, she's a Bay Area Democrat, which means that and her financial support politically comes from Silicon Valley. That is by far the most significant campaign contributor for Kamala Harris. So when you look at that and then realize that the reason why she's doing this is because people really care about it, and people are becoming more and more educated about the significance of data breaches, and we're going to see more and more and more data breaches. I mean, every month that goes by, more companies are collecting more data across the board, where it used to just be the big guys, the Googles, the Microsofts, the Apples of the world, because technology technology decreases in price over time. Smaller companies are now able to gather data that would have been cost prohibitive to gather, not too many years ago. So you have a lot more companies gathering a lot more data. You have an explosion in the use of mobile devices and people accessing far more information on their mobile device than ever before. And these trends are going to continue, which means there are going to be more companies overstepping their bounds and collecting private data and misusing it, and more opportunities for hackers to steal information from companies that are not being as careful as they should be or spending the money that they should be to protect that data.
Well, I think you're also seeing more companies coming forward, and whether that's just a sense of corporate responsibility, which I don't buy, I think it's more a sense of fear that if they don't do it, they're reading and hearing about companies that are getting hammered by HHS, OCR, whether it's an AG, whoever it is, and I think that they are starting to become more knowledgeable about this, and they're concerned about it. So I think you're starting to see more companies. We're starting to see more middle market and smaller companies that we would have never imagined even a year ago coming forward and asking us for help because of a breach and wanting to step up and deal with it. But now we're starting to see more of that.
And I would also challenge you, John, on the idea that these cases aren't working, because they are settling. I mean, some of these cases are settling, and I think one of the reasons why is, as Tim pointed out, the public narrative surrounding these issues is heating up, and so it's becoming easier for judges to adopt our theories that, oh, actually there is some harm here because this is very important information. People care about these issues. But the other thing is that the law is being shaped right now, too, and John has asked me to name some cases so we sound like real lawyers, but in the 11th Circuit, which is a federal appeals court that covers the Southeast, and the First Circuit Court, which is an appeals court that covers the Northeast. These two cases, one's called Hannaford, one's called Avmed. You've seen these federal appellate judges say, look, even though we can't exactly at this time quantify exactly how much folks are harmed, we're going to agree with you at this stage, the early stage of the lawsuit, motion to dismiss stage, that the plaintiffs have alleged enough if they said that they have been the victim of identity theft to proceed as a class action. So, I would say two things. One is that these cases are working. Otherwise, I think we would probably stop pursuing them. But the other thing is that the law is being shaped, piece by piece across the country. And until we see sweeping federal legislation to cure this stuff, we're probably not going to see a silver bullet answer from the plaintiff side. But the more government action we see, it's actually the better for us too, because the FTC is heating up, the SEC is heating up, and discussing these issues, HHS, like Tim said. And so we can actually cite these things in our lawsuits. It's persuasive authority to a judge to say, oh, these guys aren't just full of shit. The HHS is looking into this, the FTC is looking into this, and so these are important issues.
And I think the carrier side experience certainly bears that out. None of these cases are ultimately finding themselves in, they never get to the jury stage based upon the facts surrounding the case, the potential cost of defense, all these things are settling out. And the carriers who are defending these see a lot of smaller and medium-sized settlements. that don't necessarily find them, you don't necessarily find on the pages of the Wall Street Journal.
And when we talk about, again, these published decisions, you get down to the smaller cases in these circuit courts or state courts. And our most recent class action, fortunately we got out, but as I sat and watched some of the other motions, the judge made a comment. It dealt with health information. He said, well, you know what? If those were my health records, I might feel really embarrassed about that. So his standard was, how embarrassed would I feel if that was my information? Forget about the law, forget about the cases. That's troubling. The other thing that he said, which was troubling, and again, he had no background in cyber or data or anything related to this, but one thing he did know was something called the Uniform Trade Secret Act. And the Uniform Trade Secret Act has been adopted in 46 states. And it's interesting because he was analogizing the tie in the damages to the case at hand involving these medical records in this Uniform Trade Secret Act. And in that statute, they talk about a misappropriation of trade secrets or a threatened misappropriation of trade secrets. So here's someone who doesn't understand really the state of the law, but is pulling at areas that he does understand and trying to analogize it, which is just going to open the door for my friends here on my right and left
Yeah, I'm writing that down
to have
right
a
now.
field day with this.
These types of cases also, they're very much, they're driven by what happens at the motion to dismiss stage. So right out of the box, complaints filed, defendant files a motion to dismiss, and that's really where the battleground has been over these cases. Mm-hmm. If they get past the motion to dismiss, it's for a number of reasons. They're sort of oddball sort of claims that don't necessarily fit perfectly within a number of different causes of action. Or they do, but it's the wrong kind of causes of action for a class action. But once you get a claim that the judge approves, they're really pretty easy from there on out. Class certification's not really an issue in these kinds of cases. The customer hasn't done anything wrong. The customer isn't an actor. One general way to look at whether a case is good for class certification is, how much of it depends on what the individual class member has done or should be doing or has to prove up versus how much of the conduct is centralized with the defendant. Well, these are way over here. These are all centralized with the defendant. They're like the securities fraud cases where everything that happens on the defense side of things and the customer is just kind of going along for the ride. So class certification is by and large not much of an issue. Also, discovery. I mean, the plaintiff's lawyers put together these cases, and the facts can be shocking. But wait until we get into discovery. I mean, usually what happens is sort of the joke is, the case is at its best when you file it, and then it goes downhill from there. Yeah. This is the reverse because you guys most of you in this room know what's there and what happened behind closed doors and where this information can be used, why the information got hacked, or the decisions in a misuse of private information case, why the company took the information, what it used it for, and how it violated its own policies. These cases get better and better with time, and plaintiffs' lawyers are raring to go to grab those facts because it's going to be a great case.
Well, considering the target has already issued a letter effectively saying it was negligent, it gets pretty tough, and then facts do not get better. I think you're right there. So, Chandler, where are we headed? Where's this whole thing taking us?
I think that what you're going to see, like I said before, is more and more federal appeals courts adopting some of these novel theories that the plaintiffs have been pursuing over the past couple of years, only because now we finally reached the frontier of this area where everyone agrees that these are important issues. So I think, for the folks in the crowd, look out because the law is becoming more and more favorable towards consumers in this area. I think you'll continue to see the legislature grapple with laws, but because different interest groups have different reasons to sway legislators one way or the other, it's going to be a while until we have some comprehensive type of legislation. I think what it's going to take is some sort of major breach that is like front page news for this type of legislation to come around. But in the meantime, I think you're going to see an uptick, continue to see a gradual uptick over the next couple of years of plaintiffs' attorneys bringing these data breach lawsuits. And I think the more that plaintiffs' attorneys like Tim and I realize that these are viable lawsuits, the more plaintiffs' attorneys you're going to see jumping in. So it's just going to be kind of a free-for-all.
Is there a buzz in the plaintiffs' world about these cases now?
Yeah, absolutely.
Do the average plaintiff's firm, if there is such a thing, actually have a clue what they're really about, or is it just sort of a specialist group?
I think as of right now, you're seeing a small group of us because everyone knows each other. But lawyers are getting smarter, and usually law lags a little bit behind business. But you're seeing attorneys like our firm, we actually hire engineers, and we have engineers in-house who look at these things and say, "Oh wait, here's the news coming out about what they're doing. That is absolutely not industry standard, and I'd be willing to be an expert in this case and be deposed and talk about why these things weren't up to code." And so the more you see plaintiffs' firms doing that kind of thing, bringing people in-house to look at these issues, you're going to see a continual uptick.
So if you're your own forensic investigator in-house?
Yeah.
That's an investment. Okay. Tim?
And I would just add one thing, one additional thought is, because the law is going to be getting better over time, I mean, the thing about a bad case is, I see a bad case, that's just something I have to work around. But if I get a good decision, particularly at the appellate level, then I know exactly how to approach that case in the future, the next case in the future, so I just mirror that good case. And we're seeing the case law improving in this area. That and the increased sophistication of the plaintiffs' lawyers who are focusing in this area is going to lead to larger settlements. It just will be. A lot of the settlements have not cost that much money as far as cash out of pocket relative to what I think we will start seeing in the future, because the plaintiffs are going to feel more and more secure about their cases, and then that'll obviously, of course, those cases will become more widely known, and then you're going to have other players come into the marketplace because they're going to say, well, I want to start doing these cases too. And also, the thing about these cases, and somebody on an earlier panel made this point, and it's absolutely true. These are the cases where you get the phone call that says, "I am so angry, I am so furious, will you represent me?" And that's exactly the kind of class representative you want, because the company mishandled that person. And that's what plaintiffs' lawyers like, is when the class rep calls up and is just absolutely outraged by being treated badly, and then there's good facts behind it.
It's not like those people get a lot of money at the end of the day.
No, but a lot of people are willing to, and a lot of people are willing to do it because they're furious that this is happening, and that's what motivates them.
Jim?
Well, unfortunately, and it's a rarity, actually never, but I will have to agree with both of these guys that we are seeing the defenses getting eroded by the courts, and there's certainly a sense that the courts are trying to find ways to do that and to provide a remedy to folks that they do feel like they should be compensated, and we're starting to see that, and I think it's just a matter of time. And I would certainly agree that more and more plaintiffs' firms that don't have the expertise and aren't really that great at doing this work are getting into the mix, and you are going to see an influx in those cases.
Brad, any thoughts?
No, I just think it's clear that the ship has sailed. You've got more and more law firms on both the plaintiff and the defense side building teams to pursue these. You've got state attorneys general who, state by state, are more aggressively pursuing these. You've got, starting 10 or so years ago, all the notification and industry-specific, laws requiring organizations to publicize their breaches. As more and more people become educated on, in every aspect of this area, we're going to see more. We're going to see more litigation, and I think we're going to see more successful litigation.
One of the things I found interesting in talking to these plaintiffs guys prepping for this was that they generally don't go far enough in these cases to even discover whether or not there's insurance in place. So sometimes that question's been asked up here about, well, if you have insurance, does it make you a better target? And their answer, and you can correct me if I'm wrong, was they just go for it. The insurance is, oh, by the way, in many respects. Is that fair?
Yeah, that's fair. You walk into the mediation and you're like, who are those guys sitting alone in their own separate room? Oh, coverage, great.
Right. So here's a different question. Give us a sliver of hope here, guys. Here's the sliver I need. Give me something, okay? What I need to hear is what the lawyers and the insurers and all of the vendors in the room, what can be done to help a potential defendant not get sued by you?
I think what gets defendants in the most trouble is how they behave after the breach occurred. That is the single most important thing for a defendant to deal with and avoid actually becoming a defendant. They need to be upfront with their customers. They need to be aggressive. They need to not play hide the ball. I would offer, I mean, every company is always completely paranoid about, they're in a crisis state. It feels like the whole world is looking at them. It's not. And they think, if we do anything publicly, oh my God, the company is going to fall apart. That's going to be the end of it. Probably not. And as time goes on, people are going to be more and more used to, the public is going to be more and more used to learning about breaches. And so if you have a company that comes up and says, this is what happened, these are the steps you need to take, I don't think it's going to have the reputational harm that companies often sort of are overly concerned with.
Chandler, do you have anything?
I would just add that, like I've said before throughout, if you are saying that you're going to do something with consumer data, make sure you are doing that thing, or else you are going to be found to be breaching the terms of your own contract that you've created, right? So if you're saying you're taking commercially reasonable efforts to secure credit card information, then have an auditor come in and have a stamp that says, yes, these people are actually using commercially reasonable efforts to secure credit card information. And so during discovery, we'll get that and we'll say, oh, well, that's a bad fact for us because they actually were taking the time and the resources to do the things they said they were going to do.
Yeah, at some level that could be the worst case scenario, right? You have a client who actually knows what to do, writes it up properly, and then promptly ignores their own write-up, and that's really helpful on the defense side of those cases, I got to tell you. We have a couple minutes left. I am not going to hold people late for lunch. If anybody has some questions, you don't get too many shots at these guys, so go for it. Ollie, I see you have one.
Just a quick question. How do you square the circle when, on the one hand, encouraging clients who have had a breach to notify everyone and be very comprehensive in their approach, and then what we heard earlier about breach response, saying you shouldn't over-notify because you can get yourself in trouble by having to then explain that you've notified people who actually have not been affected by an incident?
I mean, I think that, I think generally speaking, customers understand that hacking can occur despite, crimes can be committed despite companies' good efforts to protect against the crime being committed. I think people inherently understand that. And when it happens, they want to be treated fairly. They want to have a sense of being treated fairly. I mean, I can tell you that the phone, a case that catches on fire is a case where the customers are absolutely furious at the way they were treated by the company and not sort of the original act that might give rise to liability.
Anybody else? All right, so there is one more.
That's a good question. So in the past, and
They don't care about the class members.
That is untrue. That's what defense firms will say about us, but don't believe the hype. In the past, what we've seen, these settlement structures are the class members usually receiving some sort of identity monitoring or credit monitoring. But, and I was going to mention this earlier, over the past couple of years, we've started to see judges look at this with a bit of a jaundiced eye because they say, well, you're giving them credit monitoring, but it only lasts a year. It only lasts 2 years. And what we know about a lot of these sophisticated hackers is that they'll lay dormant for a few years until they start misusing people's information. And so a good, robust settlement structure should probably provide for some sort of credit monitoring that extends out into the future and can be triggered if something goes wrong. The other thing is that look to see companies in the future starting to pay real dollars out of pocket in these settlements, not just credit monitoring. Again, so the idea being these folks have been paying for this service for years and years and years, and they thought their data was being protected, and it was not being protected. They want that money back. And so as nice as credit monitoring is, money talks. People would rather get the $100 in the mail or the opportunity to make a claim to get the $100 than to get a year or two of credit monitoring.
Well, that's for those cases where money ultimately changes hands. I think in a very large percentage of these settlements, the focus is on injunctive relief, changing terms of privacy policies, things like that. Also, some provision of services, provision of coupons for future credit, things like that.
We'll also see defendants agreeing to injunctive relief that basically orders them to have a third-party auditor come in for several years after the settlement, somewhat similar to like how the FTC uses a consent decree to require people to comply with an order for 10 years.
So, Tim, I hear the jet engine spooling up. Next year, we're going to call this the enemy at the gates, and thanks for coming, guys.